When you think of a life sentence, what comes to mind? Probably hardened criminals, people who have committed the most serious offenses imaginable. But what if I told you that in Texas, kids, some as young as 14, have been sentenced to spend the rest of their lives behind bars? It sounds unbelievable, but it's a harsh reality. Today, we're diving deep into the controversial world of juvenile life sentences in Texas, exploring the stories that often go unheard and the complex legal battles that surround them. Stick around, because what you're about to hear will challenge everything you thought you knew about justice. Let's start by understanding the landscape. Texas has a reputation for being tough on crime, and that extends to its juvenile justice system. For decades, the state allowed for life sentences without the possibility of parole for offenders under the age of 18. This practice put Texas in a small, controversial group of places around the world that imposed such harsh sentences on children. The core idea was that for certain heinous crimes, age shouldn't be a shield from the most severe punishment. But this raises a huge question: can a child, whose brain isn't even fully developed, truly have the same level of culpability as an adult? This is where the science comes in, and it's fascinating. Neurologists and psychologists have shown that the prefrontal cortex, the part of the brain responsible for impulse control, long-term planning, and understanding consequences, doesn't fully mature until our mid-20s. This means teenagers are biologically more prone to impulsive, risky behavior. They are also more susceptible to peer pressure and have a greater capacity for change and rehabilitation than adults. The Supreme Court of the United States has actually recognized this science in a series of landmark rulings. In 2012, in a case called Miller v. Alabama, the Supreme Court ruled that mandatory life without parole sentences for juveniles were unconstitutional. They said it constituted cruel and unusual punishment. The key word here is mandatory. The court didn't ban these sentences outright, but it said that judges must consider a young offender's age and all the circumstances surrounding their life and the crime before handing down such an extreme sentence. Then, in 2016, in Montgomery v. Louisiana, the court made this ruling retroactive, meaning it applied to everyone who had been sentenced as a kid, potentially giving thousands of inmates a second chance. So how did Texas respond? Well, the Texas legislature changed the law. Instead of life without parole, they created a new sentence, life with the possibility of parole, but only after serving a staggering 40 years. 40 years! For someone sentenced at 15, that means they wouldn't even be eligible for a parole hearing until they are 55 years old. Critics argue this is basically a life sentence in all but name, calling it a de facto life sentence. They believe it still fails to give these individuals a meaningful opportunity for release, as the Supreme Court intended. Now, let's get into the stories, because that's where the human impact really hits home. Take the case of Bobby Moore. In 1980, at the age of 20, Moore was involved in a robbery where a store clerk was killed. While not a juvenile when he committed the crime, his case became central to the debate about culpability. Moore had significant intellectual disabilities, with an IQ in the range that often defines intellectual disability. He couldn't tell time or understand the days of the week, yet he was sentenced to death. For nearly 40 years, he sat on death row as his lawyers fought, arguing that executing someone with his level of intellectual disability was unconstitutional. The Supreme Court eventually agreed, and his case forced Texas to reevaluate how it assesses intellectual disability in capital cases. While he wasn't a juvenile offender, his story highlights the system's struggle with assessing the true mental state and culpability of an individual. Let's look at another case that directly involves a juvenile. Consider the story of Terrence Andrus. At 20, he was sentenced for a carjacking. During his sentencing, his lawyer presented almost no mitigating evidence, no information about his incredibly difficult childhood, which was filled with trauma and instability. The Supreme Court later reviewed his case, not because of the sentence itself, but because of the ineffective assistance of his counsel. They sent the case back, emphasizing that for any sentence, especially a severe one, the court must hear the full story of the person's life. This is especially critical for young offenders, whose backgrounds often play a huge role in the choices they make. These cases are part of a larger, ongoing battle. On one side, you have prosecutors and victims' rights advocates who argue that for the most terrible crimes, a long sentence is the only way to ensure justice for the victims and safety for the public. They point to the devastating impact these crimes have on families and communities, and they believe that the 40-year rule provides a necessary and just punishment. They feel it is a compromise that acknowledges the offender's age while still holding them accountable for their actions. On the other side, you have defense attorneys, child advocates, and reform groups. They argue that a 40-year minimum sentence ignores the science of adolescent brain development and the human capacity for redemption. They believe that everyone, especially someone sentenced as a child, deserves a meaningful chance to show they have changed. They point to countless examples of former juvenile offenders who, when given the chance, have completely turned their lives around, becoming productive, law-abiding citizens. They argue that keeping someone in prison long after they have been rehabilitated is not only a moral failure but also a massive financial drain on taxpayers. The debate often comes down to a fundamental disagreement about the purpose of the justice system. Is it purely for retribution, for punishment, or is it also for rehabilitation? For young people, most would agree that rehabilitation should be a primary goal. But when a sentence requires them to wait 40 years before even being considered for parole, many question whether that's a genuine opportunity for rehabilitation at all. Imagine being 16 years old and being told that your next chance at freedom is when you are 56. The psychological impact of that is immense. It can extinguish hope, which is often the very thing that drives a person to change and better themselves. Furthermore, there are significant racial disparities in how these sentences are applied. Studies have consistently shown that minority youth are disproportionately sentenced to long prison terms compared to their white counterparts for similar crimes. This adds another troubling layer to the debate, suggesting that systemic biases are at play in determining who ends up spending their life in prison. So, what's happening now? The fight continues in courtrooms and in the Texas legislature. Advocates are pushing for what they call a second look. They propose that after a certain period, say 15 or 20 years, an individual sentenced as a juvenile should have their case reviewed. This wouldn't be an automatic release, but a chance for a judge to look at what the person has done while incarcerated. Have they pursued education? Have they shown remorse and maturity? Have they addressed the issues that led them to offend in the first place? It's a system that balances accountability with the potential for redemption. This conversation is happening not just in Texas, but all across the United States. States are grappling with their own histories of harsh juvenile sentencing and trying to find a path forward that is both just and humane. The stories from Texas serve as a powerful, and at times cautionary, tale. They force us to confront difficult questions about crime, punishment, and the nature of forgiveness. Should a terrible act committed by a 15-year-old define their entire existence? Or do we believe in the power of people to grow, to change, and to earn a second chance? There are no easy answers here, and every case is unique, filled with pain and complexity. As we've seen, the legal and ethical issues are incredibly tangled. From the science of the teenage brain to landmark Supreme Court decisions and the heart-wrenching personal stories, the issue of juvenile life sentences in Texas is far from settled. It challenges our society to decide what we truly value: retribution or rehabilitation, punishment or potential. Thank you for watching and for engaging with such a complex and important topic. If you found this video insightful, please give it a like and subscribe to our channel for more deep dives into the stories that shape our world. We'd love to hear your thoughts in the comments below. See you next time.